Now that the Renters' Rights Act is in force, if you're a landlord, do you know what you need to do to evict a tenant and to get your property back? Well, you can't use the Section 21 no-fault evictions process anymore. It's not only a lot more complicated now, but the local authority can impose significant civil penalties on a landlord if they break the rules. In this video, I explain the key points that landlords in England need to understand about how to evict tenants without breaking the rules in the Renters' Rights Act. It also includes a walkthrough of the new Form 3A and the type of things that might lead to penalties and rent repayment orders. I'm Suzanne Smith, lawyer turned landlord, and I'm the author of this best-selling book, The Good Landlord Handbook, which is now published by Penguin. And it goes through every stage of the tenancy, explaining how we need to operate now. And it does include terminating a tenancy as well. I also run the Independent Landlord website and this YouTube channel, and you can sign up for my free Friday newsletter to keep up to date on theindependentlandlord.com/subscribe. Let's start with what's the process now for evicting tenants in England. Well, first of all, a landlord must have a ground for possession. The days of not having to give a reason, no fault evictions have gone. And so the only way for landlords to evict tenants who have an assured periodic tenancy, and that includes an assured short-hold tenancy that converted into being an assured periodic tenancy on the 1st of May 2026. So the only way that landlords can evict these tenants is by using the process under Section 8 of the Housing Act 1988. To end a tenancy and evict a tenant, landlords must also have a valid reason called a ground. There are now 37 grounds, and if you don't meet the criteria for any of these grounds, you can't evict a tenant or ask them to leave. And if you try and do it any other way, for instance, trying to serve them a notice to quit or asking them to leave orally, then the local authority can issue you with a civil penalty of up to £7,000. And it's an offence to rely on a ground knowing that you won't get an order for possession. And if the tenant moves out, then the civil penalty is up to £40,000. And the tenant can also apply to the first tier tribunal for a rent repayment order of up to 2 years' rent. So this all means that you have to make sure that you qualify for a ground and follow the Section 8 process if you want a tenant to leave. Now, I'll go through an example of some of the grounds, not all 37 of them. Two popular grounds are ground 1, if you'd like yourself, your partner or close family to move into the property, and ground 1A when you want to sell up. You need to give at least 4 months' notice, and the notice can't expire in the first 12 months of the tenancy. And once you serve a notice using either of these grounds, there's a restricted period when you can't relet or market the property for reletting for 12 months from when the notice expires. So this means that it's at least 16 months from when you serve the notice. And these are both mandatory grounds, which means that if the judge is satisfied that the ground is established, then he or she has no choice but to grant an order for possession. Another popular ground is ground 8, and that is serious rent arrears of at least 3 months on the day that you serve the notice and when you go to court. The landlord needs to give at least 4 weeks' notice for this. This is also a mandatory ground. There are also 2 discretionary grounds for rent arrears, which means that the judge can decide whether or not to grant an order for possession based on whether they think it's reasonable to do so. Another discretionary ground that I think will be popular now that Section 21 no-fault evictions have been abolished is ground 12, breach of a term in the tenancy agreement other than rent. Now, examples might include running a cannabis farm in the property, subletting without consent, or refusing to let the landlord or the letting agent access to the property to carry out an inspection or to do a gas safety certificate. The next important thing in the process, once you've got a ground, is the notice of possession, and that is called Form 3A. And you need to give this Form 3A to your tenants. Form 3A tells your tenants that you want them to leave the property, and it puts them on notice that you intend to apply to the court to take the property back if they don't leave. I recommend getting a specialist solicitor to fill in Form 3A for you, as it's very easy to get wrong. And watching this video is not the same as getting legal advice. It's not legal advice. But here's a few pointers for Form 3A. First of all, question 2.1, and it says that your landlord cannot bring proceedings for possession earlier than, and there's a date. And this is the date when your notice is due to expire. And that depends on the grounds. For grounds 1 and 1A, it's 4 months. And for ground 12, reach a tenancy agreement, it's 2 weeks. And if you're relying on more than one ground, you must wait until the longest period of the possession grounds expires, unless you're seeking possession on the grounds of antisocial behaviour, that's grounds 7A and 14, in which case you can enter the date, you serve the notice and apply to the court immediately. So it is quite complicated. When inserting the date, I would add another week just to be on the safe side, and that way there's no dispute that you haven't given enough notice. And the next one is 4.1, which is optional. It's a list of the most common grounds like rent arrears or the landlord wants to sell up. And if your ground isn't there, tick other. The next one is question 4.2. It asks for the possession grounds as set out in the Housing Act 1988. There's a document that sets them out called Form 3 Legal Wording for Possession Grounds, and you should cut and paste the wording for the relevant ground into the form. If you don't do this, then the notice won't be valid. And the final question I want to flag to you is question 4.3. It's the landlord's explanation of why each possession ground is being used. This is where I think you need a solicitor to help you, as you need to explain how and why you believe that you are legally able to use the grounds for possession. And if you get it wrong, you could get a civil penalty as well as the notice being invalid. The next thing to flag is tenancy deposits. To use most of the grounds, apart from antisocial behaviour, you will need to be able to show that your tenant's deposit was protected in a government-approved scheme and that you complied with the requirements of the tenancy deposit scheme and you gave your tenant the prescribed information duly signed. And if you haven't done this, make sure you either return the deposit to the tenants or protect the deposit in a scheme straight away. It's a good idea to serve another copy of the prescribed information duly signed to the tenant when you send Form 3A, even if you've sent it before, as it just makes clear you've already complied with it. However, as I said, you don't need to have served the prescribed information or protected the deposit if you're relying on grounds 7A or 14 for antisocial behaviour. Prior notice. For some of the possession grounds, you must have told your tenant at the start of the tenancy that you may use them. This is called giving your tenants prior notice. It's usually included in the tenancy agreement under a prior notice clause. For instance, ground 4A for evicting students in an HMO where a property is required for new full-time students in line with an academic year is one where you need to give prior notice. Another thing to be aware of is breathing space. If you've been told that your tenant is in breathing space, you must not use Form 3A to seek possession on the grounds of rent arrears unless a court has given you permission. And you must also not issue proceedings using the rent arrears grounds 8, 10 or 11 if you've been notified that they're in breathing space. So breathing space is a scheme that provides people with problem debt with a temporary pause on creditor enforcement action to give them space to speak to a debt advisor about how to address their debts. And a standard breathing space is available to anyone with problem debt, and it prevents landlords from issuing proceedings for up to 60 days. A mental health crisis breathing space will last for so long as the tenant's NHS certified mental health crisis treatment lasts, plus 30 days, and it can easily run for many months. Now let's move on to talking about serving Form 3A. A landlord must serve a separate Form 3A notice on each of the tenants and keep a copy. If the tenancy agreement specifies a method of service, then follow that. Otherwise, you can serve it by handing it to the tenant, which is the most reliable method, or delivering it to the property yourself and posting it through the letterbox if your tenant is not there, or sending it by post to the property. And you can send it by first class post as long as you have a proof of receipt stamped from the post office. You should only serve by email if the written tenancy agreement specifically allows for email service, and I recommend only using email as a backup after posting the notice. Keep a record of how and when the notice is served, and you can do this by completing a certificate of service called Form N215, or write served by your name and the date on the notice, and you'll need this as evidence if you apply to court for an order for possession. If served by first class post, ask for a certificate of posting from the post office and take a photo of the envelope being handed over just to be on the safe side. The law deems the notice to have been served the second day after posting. And if that's not a business day, it will be the next business day. Well, what happens if the tenant doesn't leave by the date specified in the notice? Many tenants do move out before the notice period expires. However, tenants can legitimately stay in the property and don't need to move out before the notice expires, and they don't even need to move out afterwards unless a court has told them that they need to move out. And so if a tenant doesn't leave after the notice period expires, then the landlord mustn't try and change the locks or tell the tenants to leave. Instead, they must apply to the county court for an order for possession. So these are called possession proceedings, and it starts with a possession claim using Form N5, that's the claim form, and Form N119, the particulars of claim, accompanied by a proof of service, copy of the tenancy agreement, and evidence for each ground. The court will issue the claim, allocate a claim number, and fix a hearing date, and send it to the tenants by first class post. The tenant usually has 14 days to respond with a defence. At the hearing, the judge will decide whether the ground is proved, and for discretionary grounds, whether it's reasonable to grant a possession order. And the judge will either grant an outright possession or make a suspended order with conditions, adjourn with directions, or dismiss the claim. If the tenant doesn't move out by the date set by the court in the possession order, then the landlord will need to take enforcement action by obtaining a warrant for possession. The landlord can do this by completing a warrant for possession, which is Form 325, and send it to the same court that heard the possession claim. The final stage is repossession or enforcing the order by appointing court bailiffs or a high court enforcement officer. This whole process can take a number of months. So possession proceedings are complicated, and the consequences of getting them wrong are serious, both for the landlord and the tenant. And if you're thinking about evicting a tenant, speak to a qualified solicitor before serving a notice. The cost of getting it right is always less than the cost of getting it wrong. And don't forget that you can keep up to date for free by signing up for my free newsletter at theindependentlandlord.com/subscribe. And for a practical guide at every stage of the tenancy, there's my best-selling book, The Good Landlord Handbook, published by Penguin. If you have any questions, you can ask me at twice monthly live streams in my membership, theindependentlandlord.com/hub. See you soon, and hopefully in the hub.